A murder case that we couldn't take our eyes off of in 2024 is about to grab us by the neck once again. Opening statements in the retrial of Karen Read are now just hours away in the same Massachusetts courthouse as the first trial, with the same judge, same charges, and of course the same facts. But this jury may already know those facts going in. I know you do. The police officer boyfriend dead in the snow, prosecution's theory that Read ran him over, the defense's theory that Read was set up by cops who had a beef with him that went too far. So who's got the stronger case going in this time round? She doesn't even have to make a case, right? But holy cow, does she ever have one? Earlier today, I spoke with Mark Geragos, renowned criminal defense attorney and longtime friend of the show. Here's our conversation about that. Mark, what's your 30,000-foot view on the Karen Read case, part two? I feel like we've been to this rodeo before, and so have many people in that jurisdiction.
I'm very perplexed by this case in a lot of ways. Number one, I don't understand how the prosecution actually got a hung jury the first time around. I mean, you take a look at the evidence in this case, and it just goes to show you that jury selection is everything, because if you gave this case to most jurors would say this is the definition of reasonable doubt. So the second time around, I don't think that it's gotten better for the prosecution. I mean, if you are talking about having an investigating officer or an officer who's close to the investigation getting terminated between trial number one and trial number two, that certainly is a blow to the prosecution.
And also, Karen has been able to hire a juror from round one who happens to be a lawyer. And I assume that is pretty powerful ammo.
Oh, I did that once, actually twice, where I've hired a juror from a previous case. And it is unbelievable the insight that you get from the jurors after they have sat on it. I've often said to jurors, and it's not my thought, it's theirs. When I talk to a jury afterwards, it's inevitable. It happens almost every single time that those 12 jurors who are deliberating come up with something that neither of the lawyers thought of was that important. And it was something that kind of supercomputer, artificial intelligence kind of symbiotic relationship of 12 people produces. I mean, it is really an amazing phenomenon, one of the beauties of our Constitution, because they really go deep and they look at it from a lot of different angles.
So the one thing I think of when I think of the overall information that I have learned from trial number one, from, you know, the docuseries, and even go down the rabbit hole on any piece of social media. But the number one thing I have sort of boiled it down to is that she has a bigger, more robust case that someone else did this than the prosecutors have that she did this. That's fine when you're outside of court, but how do you streamline that and get that to the jury when you're inside of court?
Well, a lot of times the conventional wisdom is that the second trial, and I've had my share of them, so I've seen it. The second trial, the conventional wisdom is better for the prosecution. I don't think that's the case here. I think that they have seen exactly how this has unfolded. I think Alan Jackson, and in full disclosure, I've known him since he was a young DA. Alan Jackson has the advantage here. I think if you're handicapping this, he now knows where everything is going to be. He now knows exactly what people are going to say or not going to say. That does not help the prosecution because, as you've said, there is a robust case when you tick off the items. Whether it is the coroner, whether it is the injuries to others who were there, whether it's the texting, whether it's the kind of motive of the investigating officer and the horrific things he was saying about her and their predisposition, the fact that there were independent witnesses who did not see what later miraculously turned up. I just think it's as powerful a defense case as I can think of in recent history.
I feel the same way. I can't believe that they chose to re-prosecute just based on the strength of the evidence that Alan Jackson and Karen Reid put together for the first defense. The only thing I think of, and this is, I mean, again, this is just off the top of my head, is that the strongest evidence they have against her is that she put her car in reverse and went 24 miles an hour for 60 feet that night at the time when, you know, it all aligns that she dropped him off. But even that, I mean, a lot of people peel out after they've dropped someone off who they're mad at and take off. It doesn't say that you hit them. And then everything else that is strong, broken taillight in that same vicinity. His DNA is on the taillight. His hair is found on the side of the car. Those very strong pieces of evidence are equally blown away by the defense. I've cleaned my taillight off with my hand as a Winnipegger, and that's what John could have done. The hair on John, it could have frozen to the side of that car. That's easy to, you know, there's a lot of different things that you could explain away, which, as you just said earlier, is reasonable doubt.
By the way, the reversing for a period of time, I think, helps the defense. I think there's an argument there that proves that she didn't hit him, because if she hit him, there would have been some braking and there would have been some evidence based on what I know about black box technology and the technology that they have, or that they have the ability to extract. I think that actually helps her. I think the fact, you'll remember this, Ashleigh, because if I remember correctly, you did a show on this, where they flip-flopped the video as well. The prosecution did, which, you know, explanation for that, except you want to just kind of distract and deflect from what the reality is. How do you explain on the one witness, participant, whatever you want to label the person, the scratches on the knuckles? How do you explain that the injuries by your expert, your so-called expert, are inconsistent with getting hit by a car? There is a jury instruction on circumstantial evidence cases, and it's basically the definition of reasonable doubt. If there are two interpretations, one that points towards guilt, one that points towards innocence, even if they're not evenly balanced, you must acquit. And so in a circumstantial evidence case, I just don't get how the prosecution prevails in this case.
Let me ask you one more question. I don't know if they talk about a woman scorned, but it's something that bothers me every time I hear Karen's voicemails to John that night. The tone of voice, the profanity that she uses. I think the state wants to say this is a woman who was so angry, you know, that they were clearly in a fight. That's motive to kill him. I look at it like that's a woman who is so angry at a guy she thinks is currently sleeping with another woman, not sleeping in the snow. And I just wonder how a male defense attorney, Alan Jackson, puts that across to female and male jurors. Is this the voicemail of a woman who just killed her boyfriend? Or is this the voicemail of a woman who thinks he's very much alive and cheating on her?
Well, I don't have as much information as I would like to have from trial one about the male-female composition of who voted for guilt and who voted for acquittal. I would want to know that, because I generally, as a rule, as a defense lawyer, think that women are hardest on women. I mean, that's just been my experience in a whole lot of cases. And I would love to know if that held true, and what the split was, and who held out, and whether or not, if you've got an alternate juror or a juror from the first trial, what kind of insights they give you as to that very issue that you very astutely put your finger on. Because that, you know, a lot of times, and I've been there, you are on the receiving end of they didn't act right style evidence, or this doesn't hew to the common experience. You know that you traffic in that. aficionado. And I love your insight on that. That's something that a male may not, or somebody who identifies as a male, may not necessarily pick up on, but I guarantee you that Karen would probably tell AJ that. And I'll bet you that the other juror who's now acting as a lawyer has probably made that same point that you're making right now.
I can't wait for this trial. You got to come back and let's talk through it as we go through the next few weeks.
We may even take a road trip up there and do a field trip into the courtroom. So stay tuned.
Okay, I'm booking you on that day. Thanks, Mark Geragos.
Thank you, Ashleigh.
Thanks for watching. Go to joinnn.com to find NewsNation on your screen. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.